Hello and welcome back to another episode of the Avoid Crisis podcast with my co-host Alan Plyler. Alan, how you doing?
I'm doing well, Ray. Good to see you. And also, it's great to have another guest with us on this journey we've been on, talking about some really important topics, end of life type things. Maybe take a moment here and introduce our guest.
Sounds great. Yeah, this is episode 17, August the 10th of 2023. We're joined by Teresa Gutierrez, who's a trust and estate lawyer out of Los Angeles. Hello, Teresa, and thank you for joining us. Can you hear us? I think we lost her audio. Okay. So, what I do want to be make a point here, though, is that during this episode, we are not going to be giving out any individual tax advice or legal advice. The topics we're talking about today are just general information, educational. It's just information. So, if you have specific questions, specific needs, you should consult your own attorney or someone who can give you specific advice. With that, Teresa, I see you're back. Can you hear us?
I can hear you perfectly fine. Thank
All
you,
right.
Ray.
Welcome. Welcome. Tell us a little bit about yourself.
Sure. So my name's Teresa Gutierrez. I'm a California wills, trust, and probate attorney, licensed in California, based out of Los Angeles County, but I do represent individuals up and down the beautiful state of California. And I'm so happy and pleased to be here with you, Alan and the Avoid Crisis podcast to discuss this very important topic.
Actually, you kind of snuck it in there, but I think that's a great point to start. I think for our listeners is that the law in this area is individual by state. So the concepts you're going to hear today are kind of general. Some of them may be to California, but you should take this to a competent attorney in your state to be sure that what the local rules are. That's a great. You snuck that in there. Good point.
Yeah, I think that's definitely a point well taken, Ray. I know you have a national audience, so exactly, folks at home that are listening, take this all with a grain of salt. It's very jurisdiction specific. My points will be more geared toward California, so a neighboring state or state across the country might do things differently. So you'll definitely want to consult with somebody on the ground there that can best advise you as to your specific situation.
I'd like to kind of jump right in because I mean this is a great topic, and then the whole idea of planning ahead for your life, and also planning ahead for the potential of death coming at any time. Um, and there's sad news out there right now about what's happening in Hawaii, as an example, where it's so unfortunate about this this fire that's happening out there and the deaths that are coming from that. But it made me think a little bit even before this podcast about, shouldn't everybody be kind of preparing for the legal ramifications of their death and to protect their family? And so one of the questions I have is, we're talking about, estate planning, that type of thing. Is it just for the wealthy, or is it something that, more people should be considering?
I love that question, Alan, because I think when we hear just the terminology estate planning, just that word estate, I think has so many connotations for people. And automatically, this assumption is maybe a mansion or a castle and all these fancy cars. And that's really not the case. An estate, to define it in super simple terms, is anything you own. It could be a simple bank account, really. That could comprise of your estate if that's all you have. But it can include more things, such as a home, vehicles, investment accounts, life insurance policies, you name it. It's anything you own, whether it be real estate and or personal property. So no, it's not just for the wealthy. I think at the end of the day, we all have something that we seek to protect, whether it's what we have and whom we want it to go to when we are no longer here. But also, I think I would like to challenge people's point of view on what estate planning means, because I think most of us do. And estate planning does have to do in large part with what happens to our assets, anything we own once we pass away. That is a huge component of estate planning. And I think that is what most people consider when doing estate planning. But at least in the state of California, if we're ever incapacitated and we don't have proper documentation set up with respect to who should manage our assets during our lifetime if we cannot do so, and or take care of us with respect to personal decisions, so on and so forth, which I'm sure you'll ask me about shortly. If we don't have all of that designed, we can find ourselves in a situation, not just at our passing where our estate ends up in court, but also during our lifetime. So I would like to think of estate planning as something that really anybody that is 18 and over needs in some way, shape, or form, but also something that's not just a tool for what happens to us once we're no longer here, but also to protect what we've worked so hard for during our lifetime, should we ever be in a situation where we cannot manage it by ourselves.
Yeah, I mean, another kind of follow-up on that is maybe you can talk a little bit and just explain, what's involved with, for instance, an estate. What's involved with, whenever we have something like a will or maybe a living will or a trust. I mean, generally speaking, there's certain advantages of these vehicles. There's also advantages for when you set this up in your life. There's also generation skipping, those types of things. I mean, there's a lot of topics we could talk about, but maybe just at a high level, what is it that you normally see in an estate type of engagement? What do you see in a will engagement or a living will and a trust? Maybe just kind of walk through each of those for the audience.
Yes, for certain, Ellen. When you think of an estate plan, at least in California, it's usually one of two things. It's usually will-based or will-driven, or trust-based, trust-driven. And as you've indicated, Alan, there's numerous types of tools and numerous types of trust that can be implemented depending on the individual or the family's unique needs as well as goals. But traditionally, what you're going to see, like I said, is either a will-based or a trust-based estate plan. So in California, that distinction matters tremendously because in California, if we pass away intestate without, say, a will or a trust, what ends up happening is the state of California has a plan for us, and that's called the probate process, which we could talk about later if you want. So most people that proactively do planning want to ward off the time and expense of the California probate court. So then they say, well, what's the difference, Teresa, between a will and a trust? And the difference in California, anyway, is if you have a will, at least that's better than passing away intestate without anything, because in the will, you can designate who your executors will be, who are going to step into your shoes, and divvy up everything according to plan, as well as, what percentage, let's say, you want your asset distributed. The issue or the downfall with using a will-based estate plan only is that the will, much like passing away without a plan, passing away intestate, the will in California still has to be probated, meaning once the decedent passes away, his or her executors have to lodge that will with the court, and it's overseen by the California probate court system, and it is also subject to fees, the probate fees, which we can talk about shortly, versus the trust. It has a similar function in that trustees, that is, who's going to step into your shoes at your passing and divvy up your trust estate according to plan, and in what percentages, right? And that could be real estate, it could be personal property. But the distinction between the trust-driven plan versus the will-driven plan is that the trust is, in essence, an agreement. If it's an individual setting it up, it's an agreement between him or herself about how he or she wishes to dispose of the estate. As between a married couple, it is an agreement between the both of them about how they wish to dispose of their estate and in what manner. But the beauty of a trust-driven plan, at least in California, is that it does not have to be probated. So the trust is a private instrument, a private document that does not get lodged with the court at the decedent's passing, but rather the successor trustees can handle those affairs privately. So most Californians, because of the high, value of property here, usually choose to go the trust route because they don't want their California probate fees. And then, so in addition to the trust or a will, we would also set up a living will, right, which would document what the drafters' goals are at their passing. What are their final wishes? The living will will give instructions as to that point for the representatives of the decedent to know, okay, do they want cremation? Do they want burial? Do they want something else? Have they done any pre-planning that we should document in this living will? And then we take it a step further, right? Because at least in California, if we don't have a solid estate plan set up, let's say some directives that give others the benefit of our thinking, if we're ever incapacitated with respect to who we trust to manage our finances and our medical day-to-day care, we're going to end up in probate court in a process called conservatorship during our lifetime, which is, a whole nother topic we can get into. Right. So in addition to that will, the living will, the trust, hopefully you're going to also have a healthcare directive indicating some, wishes, very difficult topics to discuss sometimes, to be honest, about whether or not you wish to prolong life under certain circumstances, whether or not you wish to donate organs, be connected to a ventilator, let's say. All of those important decisions are going to be laid out, hopefully, in a solid estate plan, because in a moment of crisis or emergency, it can already be very difficult for family members to get in there and act on your behalf. And these directives aren't going to necessarily take that emotional component out of the very difficult decision-making process, but it can help mitigate conflict amongst the family, or the loved ones that are left behind, because even if they disagree with the person's wishes, at least they know, hey, that was mom or dad's desire, and mom or dad drafted this, when they were in all of their senses. And now, they need of us to step into their shoes and make these decisions, but rest assured that's what he or she wanted. So it often minimizes conflict. And in a similar vein, the financial power of attorney can be very helpful with respect to, let's say, the person that's temporarily or on a long-term basis incapacitated. The financial directive is going to implicate who can step into their shoes. Maybe they still have a mortgage that they're paying. Maybe there has to be some sort of refinancing or other, care going on, that without that instrument, again, a conservatorship is more than likely going to be required. And it's very expensive and very stressful. And ultimately, it requires court control and supervision. So the parties lose that control. And that's where things can get really challenging.
So, Ray, I know you've been set up as a financial power of attorney through a number of your clients, and you've dealt a lot with having to prepare final tax returns. And I'm sure you've seen some of the outcomes when the legal planning hasn't been accomplished, and there's quite a bit of financial damage, I guess is a good way to call it, that can occur.
Right. I've had a situation just this past week where one of my clients, the spouse, passed away, and so we contacted the IRS to say, okay, the surviving spouse is going to be, signing the joint tax return on behalf of the deceased spouse, et cetera. And the IRS is going, okay, that's great. Send it. There's a form 56. Send us a death certificate and send us the trust or the will document that specifies that the surviving spouse is the person who's to take this role. Just because you're married doesn't mean it's that way. And so something as simple as that is who can sign the next year's the current year's tax return has a process and needs these documents. If you don't have it, it just creates all kinds of turbulence and uncertainty. You have to go through a whole nother process, as you were saying, probate and conservatorship and a bunch of stuff that is easily avoided. Right? Getting back to our topic, avoid crisis. This is very complicated if you do nothing and something happens and you need it. And it's simple if you take some basic actions ahead of time and do that. So Teresa, you talked about probate. And so I think the risk of doing nothing is that, okay, so you're now at the mercy of the state and what those rules are. And there's an order of who can step in at what point, mother, father, son, daughter, cousins, uncles, aunts, so on. There's this order and hierarchy. And so obviously it's not going to be the choice of the person who passed. It's going to be the government that decides this order, and then the courts have to deal with it, and it's an expensive process. You got to get a lawyer, you got to go through all these things. What does it cost to go through probate versus what does it cost to have to plan ahead and have a plan?
Sure. No, that's a great point to make, Ray. And so I always tell people, whether or not you design your own estate plan, we all have one, at least in California, and that's the California probate code. It's really, it just boils down to that. With respect to the cost of probate, we me or myself as a probate attorney estimate that a good 2 to 7% of an estate or the assets can be lost in the probate process. And just to try and drive that home, let's just say an estate, we're going to say a very modest estate, is just comprised of a family residence. So we don't have these other fancy investment accounts or anything, bank accounts, nothing like that. Let's say, for simplicity's sake, which is still a sizable estate in California, but let's just say the home is valued at $500,000. Let's keep it simple. Probate fees in a situation like that would amount to approximately $26,000 on the back end.
Wow.
Right. But I've seen a lot bigger. I'm wrapping up a probate right now that's $1.5 million, and that's just the home. That one's about 56,000 in probate fees. Versus if you're proactive and do something beforehand, honestly, a solid plan, depending on your situation, right? You guys are tax folks, sophisticated folks, so you know that some situations, and with the sunset happening soon, I'll let you guys get into that. There might be more involved planning for people, but traditionally speaking, I think most folks in this state can probably get something done for about $5,000 or less, depending on, again, what their specific needs are. Obviously, if there's things like special needs trust or other more sophisticated planning, it's going to go up from there. But you can see the differential there, and how it would pay off to do something in advance, because I'll tell you, and these fees are not filing fees or anything like that. These are attorney's fees and fees for the representative. So that always comes out at the back end. And at least in California, what I'm seeing right now is these cases can run about 1.5 to 2 years. So we're talking, let's say decedent passed away this January 2023. We file a case. Sure, we'll get our first hearing rather quickly, usually within about a month or two in LA County. The ball starts rolling, but then there's a series of events that has to happen from filing the case to when we come back to provide a final accounting for the court, including marshaling the assets and the debts of the decedent. Sometimes the sale of the home too is what ends up happening in the probate proceedings. So these fees that we're talking about, they're not fees that your loved ones would necessarily have to front and forward. No, but they would come out on the back end, usually after the sale of real estate. On the front end, at least in California, I tell a lot of my probate clients to set aside a good $4,000 to $5,000 in filing fees, because we have to pay a filing fee to the court. Once you're appointed, or before you get appointed representative, you also have to publish the case. It's a very public process. So we have to publish it in a legal newspaper to give notification, honestly, really to creditors, to give them the opportunity to come forward. So that's another expense. Once you are appointed representative, depending on the size of the estate, the probate court will do what's called a bond, which is really like an insurance based on the size of the estate. I've seen that run, a couple thousand, sometimes more, depending on the size of the estate. The idea behind a bond is, okay, if we're going to name you, Teresa, a representative of the estate of Jane Doe, that's worth $1.5 million. We want to make sure that if you squander the assets during these proceedings, 1.5 or 2 years, that the other heirs can be made whole. So that's why we're going to make you pull out this bond, just to make sure everyone's taken care of, right? So that's a good $4,000 to $5,000 on the front end. And then you have this astronomical fee, on the back end. So a lot of people are very, shocked usually when they come to speak about a potential probate case. And usually the questions we ask up front is, okay, well, was there a will? Is there a trust? Have you searched, right? Have you searched? Let's make sure, because that would obviously be right. But sometimes we don't have a choice. And, when it comes to the probate process, at least at my firm, I'd like to think that my colleagues do the same. I try and counsel folks in a manner that's hopefully going to minimize the back and forth and the length of the process for individuals, meaning, we want to go in there hopefully with non-competing petitions. We don't want a bunch of people asking to serve as representative. It's not a cushy job. It's a job of responsibility. And like you noted, Ray, in terms of who gets what, that's all set out by code. So a lot of people have this misunderstanding. If I serve as representative, I'm going to have control and decide who gets what. That's not true. That's not true. You are a fiduciary, and the court is going to look at that chart, really simple, and see, did decedent leave a husband or a wife, children? No? Okay, let's move on to the next level of, potential heirs, and just keep working our way down.
So what I heard is mid-single digit thousands if you plan ahead. tens of thousands if you don't.
That's right.
And
That's if nobody's fighting.
if nobody's
Yes.
fighting, right, it
Yeah.
gets more than, and then full control if you plan ahead, and no control if you don't.
That's right.
So
That's
that's
right.
kind of
Full.
that's kind of your choice, listeners. There you go.
Yes. Yes. And I
All
know
right.
it's hard, right? There's so many, day-to-day things we're dealing with in life. And, as we progress in this conversation today, Ray and Alan, I have some tips because it could be very overwhelming. Like, how do I get started? What are some things I could do now to at least
Right.
some steps in the right direction? Maybe I'm not ready to get anything set up now, but what can I do right now?
So let's
Right.
run with that. What
Yep.
is a simple first step?
Sure. So I always tell people, one place you can look at straight away is on your potential pay on death account. So I'm talking about things like bank accounts, retirement accounts, life insurance accounts. I can't tell you how many times I've come across individuals who either were working on an estate plan or they have a loved one that's passed away that had these accounts and there was no beneficiary designation, right? So simple example, let's say, Teresa Gutierrez, the bank of Teresa Gutierrez, let's say I have an account at the bank of Teresa Gutierrez. Hopefully on that account, I've indicated who's going to be my primary beneficiary, for example, 100%. And then maybe I have an alternate. I should have an alternate or a contingent beneficiary number 2 listed. And what's going to happen on these pay on death accounts is when I pass away, as long as my beneficiaries that are listed show, usually, at least in California, a death certificate and a form of ID, they're going to have access to those proceeds.
Another thing too, just because you're mentioning that as a financial asset, is to also mention about the transfer on death registration for securities. Operates in the same way, allowing the beneficiary to immediately be able to take control and then um, take executive action or whatever action they want on those securities because it'll transfer over to their account.
That's right. That's right. And it's so important because let's say, even in this scenario, let's say there were beneficiary designations. Maybe there's a home. The home was regrettably not in a trust. Okay. So the home is still going to have to be probated. But if these accounts had beneficiary designations, that's at least going to allow the loved ones to have access to those accounts that can still help them wind up other aspects of the estate. Sometimes those proceeds go to, funeral and other final end of life costs that the family would otherwise not have access to. Otherwise, what ends up happening with those accounts, if there's no beneficiary designation, is they get pulled in to the probate proceedings, and we have to have somebody appointed administrator before they can access them. So, I've seen it play out in both ways. Obviously, the beneficiary designation, is a preference if you can have it. So I say, if nothing else, or if, you only have so much mental capacity to take on at the time with respect to this topic, I would say go through all those accounts and make sure there's beneficiary designations of your choosing, or maybe they're already there, but they need some updating. Go ahead and do that with your financial institutions, because rest assured, again, those accounts with a death cert and ID, they're going to pay out. It might not be right away and overnight, but if you have that, you're getting everybody set up. And then I think importantly, if you can have maybe some sort of file, right, where folks know that these accounts exist, because that's another issue I've run across. Some people come to me and say, hey, I know XYZ person had this account, but I can't find any paperwork on it. And it's like, right, your choice at that point is maybe your loved one's going to have to hire, honestly, a private investigator. And you don't want that either.
Yeah. And especially with, sorry. So especially with so many things being online now, and, and then passwords not being available, you don't even know what those accounts are, you don't know the balances. It can be a real challenge with that if you're not preparing and making sure that there is someone who's going to be able to access the information and take action.
That's right.
Yes.
So I want to, great points. I love this first step because you're right. It is the most basic thing. So I want to summarize, if I could, for listeners, what's commonly called the pay on death accounts. So it's any checking account, savings account, money market, CDs, your brokerage account where you buy and sell, stocks, bonds, mutual funds. Those are the kind of the real basic, more liquid ones. You also want to have the retirement accounts, your 401k, your IRA, your Roth IRA, 403b, your any pension that you might be entitled to. You should have those accounts should have primary beneficiaries and secondary beneficiaries as well. And then the final one is going to be annuities and life insurance policies. By the way, to the beneficiaries, none of this, if done properly, none of this is subject to income tax. So you can pass all this to your heirs income tax free when done properly. So that's the short list of the, or I guess rather long list of the pay on death accounts. Final thing, never make, this is, I will give a little tax advice, never make your trust the beneficiary of your retirement accounts, or actually of any of these accounts, quite frankly. They should be the individuals you ultimately want these funds to go to. So we talked about what happens if you don't do anything. We talked about the cost difference. We've talked about first steps. What about, let's talk about, I don't know, children. Okay, so you have young children, a little bit about special needs, but then what happens when they hit majority, when they're 18 or 21, depending on your state? What are some considerations there?
Sure. So it's kind of 3 points, or light bulbs rather, that went off when you said that, Ray. So I'll briefly touch upon all of them. So what happens to your children? So yes, a huge consideration in a solid estate plan, especially for folks or even single persons that have minor children, is what happens if I'm short-term or long-term incapacitated and cannot care for my child, or if I pass away and I leave behind my minor child. So a lot of people have the assumption, oh, grandma, grandpa will take care of it, or aunts, uncles, or godparents, right? Godparents especially. A lot of people think there's some legality that attaches to that, and there's not. So, if I pass away tomorrow, let's say by way of example, I always use myself, not others, and I leave behind a minor child, hopefully I've set up what we call a guardianship nomination, right? Which is in essence giving the court the benefit of my thoughts in my absence, saying, you know what, this is going to be attached to a guardian petition. Let's say my sibling is going to care for my minor child in my absence. They're going to attach that nomination, and that nomination after my death is going to be given considerable weight, as long as this individual is suited, hasn't racked up any child abuse cases, things like that. They are more than likely going to be nominated to care for my child until he or she turns 18. But if I don't have that, rest assured, a custody battle can ensue with respect to, and I've seen it happen. I have a case right now that's been going for a good 4 years,
Wow.
where I was successful in getting my client's guardianship. Yes, we did that, but there's a lot of visitation issues that I think could have been completely eliminated had we had the guardian nomination. But it is what it is, and we're doing the best that we can with what we have. So there is that. So if you have minor children, you should strongly consider doing a guardian nomination. And honestly, that's something you can do kind of on its own, similar to the beneficiary designations that we just spoke about, to 1-2 step in the right direction of getting your affairs in order. So I'll put that out there. But then Ray also touched upon, what happens if one of our children or multiple of our children have disabilities? Well, in those cases, separate from just a traditional trust, we might want to contemplate setting up what we call in the estate community a special needs trust. And in essence, the real kind of quick summary of a special needs trust is that what that does is it protects the child or the children with special needs. When they come into their inheritance, they might be receiving some sort of public benefits for their disability, let's say. But the fact that they have a special needs trust set up for them means that with respect to their public benefits, this inheritance that's coming their way does in the government determining ongoing eligibility for those services. So special needs trust is very important in that regard, to protect the public benefits, but also to be able to designate individuals. Let's say if I'm the parent with a special needs child, when I'm gone, I need to list individuals that can keep, kind of running the show for my special needs child. So I would do that in a special needs trust. Okay.
So excuse me, you cut out for just a second. I wanted to be sure we caught that if we can get the assets in the special needs trust that are for the benefit of that child for the rest of their life, or as long as the funds last, that it it prevents the state from being able to count that against their eligibility for state benefits or ongoing state support. Is that what
Right.
you were saying?
Yes.
Okay.
Yes. That's one component of it. And then the second component is depending on the disability or the level of functioning that this individual has, he or she might not be in a position to manage those funds or those assets. So the special needs trust would also indicate successor trustees, let's say after myself, the parent, that could step into my shoes. And I would hopefully want maybe 2 or 3 folks in succession in order of preference that would be able to do that. Exactly.
Okay. Got it.
Mhm.
And then now the child hits majority. Now,
Yes, yes, exactly. So now it's perfect season, right? Folks have just graduated from high school. They're going off to college. It's kind of that delicate kind of rite of passage where, maybe, young adults have been relying, as they should be, on their parents for support and care. Maybe they still are while they're off in college or transitioning into work life. And now all of a sudden, maybe son or daughters in another state, let's say even out of California, maybe suffered some sort of car accident. Or just got sick on campus, some sort of food poisoning, something like that. But that child is now 18 and barely 18. So wouldn't I, Teresa, as mom, be able to call the medical professionals straight away and have access to the medical file and be able to make decisions? And the answer is no. Legally, no. So ideally in these situations, what we recommend for our young folks is to set up some basic sort of college plan, right? Maybe they don't need the full-blown trust. Maybe they haven't acquired any real estate, but maybe at minimum, they should consider setting up that health directive and that power of attorney. College, that health directive and that power of attorney can help young person, they would hand it off to mom or dad, or mom and dad might somehow be involved in helping them get that set up. But if the unthinkable happens while they're away at school, mom or dad would have access through the medical directive to the medical files, because there'd be some sort of HIPAA waiver in there, giving them authorization so that the medical team knows that they're not going to get sued. And then also on the financial side, mom and dad would have access to, maybe managing credit cards or bank accounts or working with the loan agencies or the university of financial office or the college's financial office on behalf of the young adults. So it's not an automatic thing. And then so that's definitely something, that we need to think about, because unfortunately it's one of those things that sometimes folks learn about when it's happening.
Yeah, we've in this series talked a lot about trying to prepare in many different ways about end of life. And we talked about in a few podcasts earlier about just the whole idea of care, what kind of care for your medical needs, your living needs. We talked about palliative care as well. And we talked about financial planning. And then we're talking today on the legal planning. And I think the same question comes up, and that is, when is it the right time to really start taking this seriously and get something done? Should you wait till you're in your 50s, your 60s, or maybe 70s? I mean, we're all living to 100 at least. So when's the right time to start taking action on this?
Yeah, well, the best time.
I'm sorry, you cut out. You cut out right. You cut out right there. If you could repeat that, please.
Sure. So I said the best time would have been yesterday. The next best time today. I definitely caught the other segments you've done, and I think you're right. It is a universal theme. I mean, ultimately, listen, these are very difficult topics to discuss. I think just as an individual, if he or she is single with loved ones, it's, even between couples, right? It's just not something we, sit and talk about necessarily by choice anyway, at the dinner table or on the drive on vacation. It's a scary topic. I think for a lot of people, even the guardian nominations, honestly, with estate planning, that's one of the most challenging components of it, trying to figure out who in your absence would best care for your children. Even the best intentioned persons, it's really hard to contemplate your potential and capacity. I think is really hard for people. When I'm sitting here and guiding my clients through these decisions, oftentimes I get the response of, I've never really thought about that. Can you give me an example or, of how things would turn out if I made this decision or that decision, and so on and so forth. but I think it's really, something worthwhile visiting, because similar to your other series, before this one, is unfortunately with estate planning, we do run into situations where it might be too late. Sometimes it might be too late, because for us, estate planners, at least a solid estate planning attorney and a firm is going to look for things like capacity, right? We're not just going to, I could go off on the deep end here, but oftentimes if I get a call and somebody's already in a medical facility, maybe connected to, some sort of pain medication and not 100% lucid, there's probably not going to be much that we could do for them, because the whole essence behind estate planning is that you have the capacity, that you have awareness of what you own, your loved ones. Like, it's just a very, fundamental, basic level of capacity that you're supposed to have to be able to sign these contracts, because in essence, that is what they are. So if you're being medicated and you've just been operated on, that's not going to be the best time. Or if you've been diagnosed with Alzheimer's or dementia, it's not necessarily fatal. Alzheimer's or dementia doesn't mean you can't do it, but there's going to be more cost involved, because oftentimes you have to get some sort of medical clearance to be able to do it, and or have several meetings to identify times when you are most lucid over. I think we disconnected a little, but in terms of where your cognitive ability is on the decline,
Sure.
you're going to have maybe added meetings to document your capacity, especially if there's some concern that someone might posthumously challenge your plan, right? We want to take steps during your lifetime to minimize that potentiality that someone's going to try and invalidate a trust or a will because you were, quote unquote, just diagnosed with Alzheimer's. I think that's why I really think, in my experience, that planning ahead can ward off all of the things that can go wrong in this process.
With the void crisis, we've mentioned many times that you need to think and analyze. That's the first step. Then you need to make some decisions. So you need to decide and then act. And a lot of what you've covered here today is really kind of highlighting the importance of taking action on the legal side, because it's going to save money in the whole avoidance of probate. And it's also going to result in a more timely transfer of assets to your heirs. So I think it's really important to point out, if you have not considered these steps in the past, it's really a great time to do that. I think we're coming up here on our time now. Ray, maybe we can have Teresa give us a way to contact her, and if you want to learn more and meet with her.
Sounds great. I definitely want to do it. There's one last piece I want to cover, if we can squeeze it in, Teresa.
Sure.
We talked a little bit about having an attorney involved, a few $1,000s or so, depending on the complexity and so on. And for some people that may be, still not affordable. And so versus doing nothing, is there anything in between? There's something like, is it a DIY kind of thing? Is there something online or whatever that is at least acceptable, or would you say, nah, just don't even think about that?
Sure.
Yeah.
No, great point to make, Ray. We're coming out of this pandemic. It has been very challenging for people, right? At least in California, it's very expensive here. So I do respect individuals that are cost conscious and have these concerns that they're dealing with. So that's a fair question, valid question, important question. I would say be careful with the online platforms that promise you, an estate plan in exchange for a few $100s. Just to be honest, the mere recording of a deed, let's say to your trust, can cost that amount. So it's similar, like think of when you're driving down the street and you see that billboard, you're going to get divorced for $500. Again, the filing alone can cost that much. So I would, and whatever agreement you enter into with said individuals, look it over carefully and see what it includes, right? Because one issue, I just started a probate last month here in California, Orange County, and that person had done during the pandemic one of these online platforms. I won't say the platform, but there's a handful of them out there. And ultimately they sent her the documents, but they were never executed. So prior to starting the probate process, I asked her only air to please, double check the facility, make sure. And she did. She said, Teresa, I found them, but they're not signed. And I said, okay, we have to go the probate route. We're going to do it. This is how we're going to do it. So that's where I would be careful, because that's not the first time I've seen that. I've actually seen it before, where maybe a deed, because when you set up an estate plan, at least in California, you have to fund it, right? The trust.
Right.
So think of the trust like a bucket. So once we set up that trust bucket, whatever we want to be subject to the terms of that trust. So we need to put it in there. So with respect to real estate, there's usually a deed moving it to the trust. So I've seen situations where people go to these online platforms and then that deed was never recorded. So guess what? If they pass away, okay, they have a trust. That one was maybe executed, but the property was never put into the trust. So again, just be careful with what you're getting for what you pay for. But think of it this way. When you go to a medical professional, maybe for a heart condition or to a dentist for some dental work, you're going to them because that's their focus area versus, let's say, going to a vet, right? So kind of, honestly, for lack of better choice of words, you get what you pay for. But for the individual that still wants to do something, and maybe him or herself, I would say instead of these online platforms, I would go with a more reputable source. Years ago, the California State Bar, who I'm governed by, used to have a segment on their webpage about estate planning, and they had directives that folks could print and sign. So I would often refer cost-conscious persons to that link. It hasn't been active for some time, but you could check the California Bar website, right? They govern the attorneys in California, at least if you're in California. Also in California, I've often referred cost-conscious folks to the Sacramento Law Library and the Los Angeles County Law Library. So even in your home state, if you're out of California, I would look at what your local law library has to offer, because many of them do. And I've seen, at least in LA County, workshops starting again. So they'll offer workshops. And then at least Sacramento's law library, I have directed people there before to look at health directives that can be downloaded and executed, right? So maybe you just kind of feel you really need a health directive. You're going to have a procedure done or something like that, but funds are tight because of that procedure. I would go with one of those more reputable sources than some do-it-yourself online. Another horror story, just real quick, of the do-it-yourself online. There was a situation where someone did one, and then they were gifting a person to the car versus the other way around. So, so
Yeah.
just be careful.
Yeah, right,
I would
right.
say law libraries or the bar of your state. Go to them first, because they might have resources.
When you said that, you actually reminded me of one other source too that I just want to throw out. Is there are some not-for-profit organizations that have actual licensed attorneys that the nonprofit pays their salary, and then based on income, requirements, they're providing essentially free legal services to lower income
Yeah.
people. So I've seen organizations like that. So do a little research that way. But I think a point well taken, Teresa. So
Yes.
Alan, to your point, I think we've kind of gone a little over our time here, but so much information. Thank you, Teresa. If
Of course.
people want to reach out to you, and again, we're going to assume they're in California, what's your contact info? How can they get a hold of you?
Right. The best way to get a hold of all the platforms to reach me would just be my website. It is a mouthful. So it's Teresa Gutierrez Law.
.com.
So just like my name is spelled, TeresaGutierrezLaw.com, TeresaGutierrezLaw.com. You'll get phone number. You can send a message directly, and the other platforms you'll have access to from there as well.
Great. Thanks very much.
Of
Remind our
course.
listeners, follow us at avoidcrisis.com. Send us emails. Listen to our future episodes. Alan, what do we got in store in the future?
Well, first of all, let's just talk about the emails. It's Ray, R-E-Y, at avoidcrisis.com, and it's Alan, L-E-N, at avoidcrisis.com. And, we are now wrapping up on the series here about aging and elderly care. I think it's been a great series. And we're going to move into, in our next podcast, a series of AI benefiters. And those benefiters are companies that are publicly traded, where based on the Avoid Crisis research team, which is basically me, we've come up with some ideas of some investments you potentially could make. Obviously, we're not going to provide any kind of investment advice, but we're going to point out how our research, and I know, Ray, you're going to be helping me on this, how our research indicates that they will be a benefiter from AI, artificial intelligence, machine learning, and that's going to potentially result in maybe some movements of their stock. So,
Sounds exciting. We hear a lot about AI, and I think a lot of people are almost like deer in the headlights. Well, what does this mean? What do I do? How does this going to affect me? And there's different aspects. There's professionally, but then there's also just as a consumer and as an investor. So this is going to be a real interesting series, Alan. Looking forward to it. Our series on AI. Teresa, thank you again for joining us. We really
Thank you for
appreciate
having me.
all your expertise and knowledge and stories that you shared with us today. And listeners, we'll see you in a couple weeks. We're going every other week at this point. So until then, good day.